So welcome to this afternoon's Politics and Pizza event. This is the last of our school year 2015-2016 Politics and Pizza. I am most happy and really privileged to be joined this afternoon by Professor Anthony Johnstone from the University of Montana School of Law. Anthony teaches and writes about federal and state constitutional law, election law, legislation, and other related subjects. He has a very illustrative career that has included testifying before the U.S. Senate Judiciary Committee, the Montana Legislature. He's spoken at a wide range of academic and professional and popular events across Montana as well as the rest of the United States. His work's been featured in the state and national press and has appeared in places like the LA Times, the New York Times, the Wall Street Journal, as well as the National Law Journal, which named him as the Appellate Lawyer of the Week in May of 2012. Prior to
52 a year.
There you go, 52 a year. Prior to joining the faculty at the University of Montana, Anthony served as the solicitor for the state of Montana, the chief legal counsel for the state. And prior to coming to Montana, practiced law at a firm in New York City and also clerked with the Honorable Sidney R. Thomas with the U.S. Court of Appeals for the Ninth Circuit. So again, my great pleasure to welcome Professor Johnstone. So I'll turn it over to you.
Well, thanks for having me. I thought I made one little critical change in my slides. It was kind of a head-slapping omission. In talking about politics and the law and how we pick judges. Create now a political court to echo the ideas of the executive, or you could imagine any other politician, and you have created a weapon. Any idea who said that? Over maybe the United States, the greatest question of political interference with the judiciary in American history? Madison? No, it could have been. How about Burton K. Wheeler?
I was guessing, yeah.
So this was a speech he gave as he was the leading opponent of his fellow Democrat, President Roosevelt's court packing plan. And what he says about his concerns about the president's interference with the Supreme Court, the U.S. Supreme Court, is echoed in our concerns about money and politics and judicial elections in the states, in Montana. So I'd like to, while we think largely about, for example, how we're going to fill Justice Scalia's seat on the Supreme Court, U.S. Supreme Court there, 90% of judges are state judges, right? Almost all judges are state judges. And most of them, it depends on how you count, but 8 or 9 out of 10 of those judges have to face election one time or another. Not necessarily competitive elections, maybe retention elections, but most of them are elected. So judicial elections are a reality. And of course, state laws are what impact most of us, far more than federal laws, for example. So state courts matter. And they matter to people who have money and put that money into politics. So this court, this is the Montana Supreme Court. I understand they're renovating it right now, so it won't look quite so much like Star Trek. There's the justices beaming in from another star system to hear oral argument. So how do those justices get picked, set aside from the problems we're having in politics selecting the 9th justice in the Supreme Court? Well, they get picked on our ballot, right? Here's our ballot. You vote for Supreme Court justice, right? So that's Chief Justice Mike McGrath. This was his election in 2008. Justice Cotter, running for her, turned out to be final term. on the ballot. We vote for them. And if we vote for them, that means that they campaign, and both the justices and the opposing candidates, as well as various outside interest groups, are going to try to get our attention to try to win over our votes for one side or the other. A quick overview of kind of where Montana stands in the national picture and just how broad these questions are. This is a map of judicial selection in the United States. We'll walk through, kind of go through a tour of this, and it's in some ways a historical tour of how we pick judges in the U.S. The original way of doing it was, we might consider, the federal model. So the governor, just like the president, nominates, and the legislature confirms, the state legislature, just like the Senate confirms members of the Supreme Court. That was the original model in most of the early states. It is the model still practiced in places like Virginia, California, Maine, South Carolina, but it's an old and relatively rare model these days. Over time, particularly with the rise of Jacksonian democracy, you got into elections. And those elections originally were partisan elections. Partisan elections because, right, as talking to political scientists, judicial elections are low information elections. Party designation serves as a cue for voters. So it was a reform to, as we opened the franchise to more people and began electing more officials, partisan elections became one of the first innovations in judicial selection. As we transition from kind of the Jacksonian era into the progressive era, they began to have worry about party machines, and they moved towards the reform of nonpartisan elections. And so in Montana's 1889 Constitution, Montana originally was a partisan election state, and they'd gone back and forth a little bit around 1910. Finally, in the 1930s, we became a nonpartisan election state. Again, with the idea that it's more important to have them not be beholden to a political party than to provide whatever extra information there might be with a party designation. Finally, so that's around the turn of the century, early 20th century. Then finally, we have something that's often called the Missouri Plan. It began in Missouri. It was an attempt to professionalize the selection of judges, what they call merit selection. So you have a committee of prominent lawyers, oftentimes selected in part by the governor, but maybe selected by various groups, who nominate a certain group of qualified judges. And then the governor has to pick one off the list. So it tries to provide some compromise. It tries to get the politics out of it by having expert attorneys, of course attorneys who all have their own political views and interests and who's on the court, have them make the first cut and then not allow the governor to pick someone off that list, right, so that the governor isn't trying to repay a political deal or anything else. So it's an attempt to take politics out of it. That's the Missouri Merit Plan. But as we see just on the list, most states, there are a lot of states that have gone with merit selection. Those are the red states, only by code, not by partisan lean. The blue states, again, simply to code them, are the election states. But even in some of the merit selection states, you might have retention elections. So note, one of those states is Iowa. So Iowa, several years ago, the Supreme Court recognized the right of same-sex marriage in their state constitution. Those justices were put there by an apolitical merit selection plan, but of course they sat on retention elections, and 3 justices of the court were voted out for their decision in that case, in something that certainly involved political campaigning. So even those red states with merit selection, usually the compromise with merit selection is, although they're picked by professionals and lawyers and the governor, they are still subject to retention elections. So the vote is put to the people. They don't have opponents, but as their term turns over, they have to get chosen. They have to be affirmed. Their position has to be affirmed. They have to be retained by popular vote. So we have elections. Elections are pervasive in state judicial selection processes. So that means we have campaigns. And in terms of the campaigns, I took a look for a paper published last year looking in particular at the 2014 election, and more on that later, but generally looking at money and politics in Montana judicial elections. And just like campaign finance generally, money in politics had been dominated by candidate contributions. In other words, people writing checks to the candidates they support who would run the ads, and that would be it. And those contributions would be fully disclosed. In Montana, they'd be limited. And this was the story of money in judicial elections for a long time. Not a lot of PAC activity as far as we could tell, a little bit, but nothing really close with respect to the actual contributions that go to the candidates. But over time, you'll see they kind of go up and down, and those are largely based on whether it's been competitive or not. So in 2002 and 2004, those are those two taller bars. Those were hotly contested races for one was there were multiple elections. First of all, there's contested races for both Chief Justice and one of the Associate Justices. 2004, again, there were contested races. There were primaries. But generally in the lower years, the lower spending years, like 2006 or 1994, there were either weekly contested races or uncontested races. Let's see. If we look, after, right, so something happens in 2010, that's something as Citizens United, which this isn't really about corporate expenditures, but it's about Citizens United and changing the definition of corruption that states can regulate, and then creating the ability in a follow-on case of super PACs. So Citizens United said that independent expenditures don't corrupt, and so therefore whether they're corporate, union, or just some wealthy individuals, they can make unlimited expenditures to these PACs, and that opens, as long as they're independent, not coordinated, that opens it up to a lot more spending. And so this is what we see in 2012. We see almost as much outside money. It's not clear exactly how much outside money there is, because the regulatory system in Montana is still catching up. We didn't have the Disclose Act, for example, that clears some of these lines that we have this year. But then we get to 2014 and literally off the charts in terms of the amount of money spent in the 2014 election, which was contested. There were 2 seats open. It was contested on both sides. But the main event, one of it wasn't really contested. The person who was running against the incumbent Justice Rice didn't really raise much money. But Justice Wheat faced a challenger. The Solicitor General of the state, my successor, Lawrence Van Dyke, ran against him, and unprecedented amounts of independent spending. Not many more contributions to the candidates, by the way. There wasn't much more direct donations to the candidates, but that Wheat-Van Dyke election took Montana judicial campaigns off the charts in terms of the spending. I took a look at where that money came from. What we have here is the green is still the green from before. They're candidate contributions. The light green are out-of-state contributions. The dark green are in-state contributions. And you'll see that while Justice Wheat, and maybe not surprisingly as the incumbent, has slightly more in-state contributions, they both basically have the same level of contributions, direct contributions. The difference is that blue line on the last chart, now reflected in the colors I've indicated here. And the difference is all of these independent expenditures. Those independent expenditures themselves have some significant differences, and it plays into this question of both money and politics and how some federal court decisions have upset the conventional order of judicial elections in Montana and elsewhere. So first, we could take a look at Justice Wheat's campaign. Again, both of them are overwhelmingly supported. If you got a mailer or saw an ad about a judicial candidate in the 2014 election, chances are that was not paid for by the candidate. It was paid for by outside money by an independent expenditure group. So to look at Justice Wheat, above his contributions, the largest independent expenditure on his side, or attacking just as likely or perhaps more likely his opponent, is the Montana Trial Lawyers Association PAC. And then the blue is called Montanans for Law and Justice. Montana Trial Lawyers PAC is a standard perennial PAC that spends in elections, fully disclosed. So you could go through and look at their filings and see exactly who was spending money. You could use that if you had a question about a case that was pending before the court and worried about a conflict of interest, or you could raise that. You could point to it. It was fully disclosed, unlimited. So there are contributions in the thousands, or some cases tens of thousands of dollars, but fully disclosed PAC money. And remember, in campaign finance, PAC is actually a tool of reform, right? A political action committee is because it's fully disclosed, is better. It's the opposite of dark money. We've seen that get confused this campaign season, but the PAC is the opposite. It's fully disclosed. But it's a lot of outside money. Outside money that's fully disclosed, but outside money. The blue then is Montanans for Law and Justice. They are not a perennial PAC like the Montana Trial Lawyers Association. They arose for this campaign only. Most of their money came from the Trial Lawyers Association and then from other PACs, other interest group PACs. The MEAFT, so the Teachers Union, Public Employees Union PACs, some other union PACs, some other organizational PACs, environmental PACs. But again, all of those PACs were transparent all the way back. So if you looked at their filings, it was, again, not PAC money, not dark money, disclosed all the way through, so you knew exactly which individuals were giving to the environmental PAC or the union PAC, and then how much money that union PAC or environmental PAC gave to Montanans for Law and Justice. A different story when we go to the Van Dyke side, slightly more outside expenditures. And start at the top, that yellow bar, Montanans for Justice. I guess the Law and Justice, Montanans for Justice is already taken. They got to their PAC names earlier. Montanans for Justice was a PAC. It generally, like those other PACs on the wheat side, generally was fully disclosed through. Bringing in other PACs, contractors PAC. If you think about the groups that these actually end up looking a little bit like Democratic or Republican interest groups. But contractors PAC, some other business-related PACs giving to that group. But just a little bit at the top. Not, by far the smallest outside spender. Who are the big outside spenders? Well, we'll take a look at the black bar first, which I've colored black because that is truly dark money. That black bar is money from Americans for Prosperity, the Koch brothers funded group that is, other than being able to call it the Koch brothers funded group, we can't say anything else because they did not file disclosures in the state. So an outside group, but in that case, instead of PAC money that's disclosed, it was true dark money. And then finally, that big bar, which I've colored red, is halfway in between. It's a PAC, but it's a PAC that hasn't disclosed all the way back. It's the Republican State Leadership Committee. So remember, Montana elections were a state with nonpartisan elections ostensibly. The National Republican Party has an affiliate that spends in state campaigns. Usually they spend in state attorneys general offices or state legislative races. In this case, the Republican State Leadership Committee was by far the biggest spender on either side in the Montana Supreme Court race. And that money was disclosed as coming from the Republican State Leadership Committee, but you don't get any information past there. So although they were a PAC, they were a PAC in Montana that just happened to come in to about several $100,000 from their national affiliate and did not disclose beyond that. So all we know is their money came from the pool of money that the Republican State Leadership Committee gathers. We can discover their donors as a general matter if we wait for the tax returns to be filed, but they did not file campaign finance disclosures in Montana other than to say it was their money. So, and again, I don't mean to suggest there's any particular valence in one election versus another, but these are two very good examples of there's going to be outside money in judicial elections on both sides. There are going to be two kinds of outside money. One is going to be PAC money that's fully disclosed, and one is going to be what we might call dark money. And the Republican State Leadership Committee and Americans for Prosperity represent that although they sometimes file as PACs, they don't disclose where they're getting their money from. You can't figure out the people or the corporations or the unions behind them, unlike PAC money where you can. And plus we had thankfully some political scientists at Stanford helped us decide exactly who we should vote for. They sent out this mailer. It was a crazy election. This mailer is based on a methodology, unfortunately, that simply parrots back the campaign finance data that I just told you back at the voters. So in other words, the same pool of people who gave to Mitt Romney also gave to candidate Van Dyke, and the same pool of people who gave to Barack Obama also gave to Mike Wheat. There's a little bit of a queue there. I guess that was the theory of it. But the problem is, if there's a problem with the campaign finance side of it, this is just echoing it back. It's not telling you anything other than maybe some defects in the campaign finance system. It just tells you where that money's coming from. Okay, so why does campaign finance matter in judging? There's an important study by a couple of political scientists and law professors at Emory who discovered really troubling things about, in this case, they were just looking at whether you're getting money from business interests and the other impacts of independent spending. So if we think about what kind of ads these buy, they're not going to run ads that say that this person believes in the wrong liability rule for complicated commercial transactions. Right? That's not the ad that you see in these things. You're going to say, you're going to find the justice who has what you think is the wrong liability rule for personal injury lawsuits or some business interest, or is taken a position against you with respect to natural resource development or something. You're going to target that justice, but the voters are going to be bored with that business stuff. So what kind of ads are you going to run? You're going to run an ad that says that this justice let out a rapist on a technicality who went out and raped again, right? And so it affects not only the business agenda of the court, but it also affects all the much more important, right, because you're dealing with liberty rather than just property, the criminal justice agenda of the court. And what they found was quite troubling. In just business cases, a justice who receives half of her contributions from business groups would be expected to vote in favor of business interests, almost 2/3 of the time. There's a question, causation, correlation. Maybe they're just putting their money on the right horses. That's fine. But the money's there, and it seems to be at least following the results, even if it's not producing results. The even more troubling is that unlimited independent spending. So when they looked at places, at campaigns where there was unlimited independent spending after Citizens United, where there's not limits on independent spending, after Citizens United, based on a comparison of states that had limits on independent spending and those that didn't, they assumed that after Citizens United, justices would vote differently and against criminal defendants because they're scared of those ads that aren't talking about business cases but are talking about criminal cases. They're funded by maybe business or trial lawyer interests. They're funded by them, but because they attack them on criminal cases, it has an effect. 7 out of 100 cases. That's not a lot, but you probably wouldn't want to be one of those 7 cases, right? Where, but for that independent spending, the court might have decided differently. Television ads. Again, the more ads that are run, I suggest in a state with 10,000 ads, I have no idea how to calibrate that to where we are in Montana, but a doubling of TV ads would change a justice's vote in 8% of cases. So a small but significant effect. And when you're talking about equal justice, any skew is too much. So these campaign ads have a problem. Where did this all come from in terms of the campaign money? Right? Citizens United sets up this idea that just mere undue influence is not a problem. In fact, the court has argued and has continued to argue that in our system of democracy, I don't get this from the Constitution, not even from the First Amendment, but in our system of democracy, it's public officials' job to be responsive to their voters and supporters and contributors. And then, although recently, troublingly, in later cases, they said they have to be responsive to their voters or their contributors. And then finally, what they've said most recently in cases involving judicial elections is we expect them to be responsive to their contributors. The voter kind of drops out of the picture, which I don't find in the guarantee clause, which guarantees a Republican form of government. But the court has blown open this idea and said, basically, if it's not bribery, we shouldn't care. In fact, it's not a bug in the system, it's a feature in the system that they should provide access and influence to people who give money to candidates. Now, I'll say that by a 5-4 vote with Chief Justice Roberts peeling away from the conservative majority in Citizens United, the court recently said that judicial elections are different. We don't know quite how different. It was in a minor case dealing with a weird law that Montana doesn't have. But so far, the impact in the lower courts has been for Citizens United to upend judicial campaigns, as well as other political campaigns. That began with American Tradition Partnership, a case that I was proud to represent the state in what turned out to be a losing cause. First, it eliminated, corporations can make expenditures. And again, that money is not, maybe some of the big, some of that money may be coming from corporations, but it's not the corporations that are the problem. It's the unlimited and in some cases undisclosed money that's really making up most of these campaigns. So that's one of the first bricks in the wall. The next, mixed metaphors, the next shoe to drop. But the next thing that's coming, this is in front of a federal court right now, we'll say, and if only bribery corrupts under Citizens United, then you have to get rid of your contribution limits too. So now you'd have unlimited contributions to candidates as well. So some of that money would go directly to the candidates. The limits for Supreme Court justices are $320 right now. There's a judge right now considering whether to blow the top off of that. That would affect not just our legislative and other elections, but they've just lumped in justices. Judges are just the same. Donors to justices have the same First Amendment rights to donate as much as they want and expect them to be responsive. That's the argument. But that's only one piece of the post-Citizens United stuff. There's campaign contributions and expenditures, that's one side. But you also have this political endorsement. Remember that big red block of the National Republican Party spending in our nonpartisan state campaign. That door was opened by a case that came after Citizens United called Sanders County. Interesting question. You had this mom and pop type Republican Central Committee that said that we just want to put on our Facebook page a local judge that we like, we want to be able to endorse. To my knowledge, they actually never have endorsed anyone, but they'd opened the door, maybe knowingly, to the national. So it's not the Sanders County Republican Central Committee that is endorsing one of the candidates there. Right? It's where the money is. It's the national party. And the court says you can't stop that. If you're going to have judicial elections, you have to let political parties endorse, is the logic. Not all the judges agreed with that, but 2 judges did. And so therefore, although the judges, and it's actually being challenged right now, whether judges can accept the endorsements. Right now, the law still says judges can't accept political party endorsements. That's being challenged now. But for now, the parties can endorse judges. I think the parties have been careful not to do that. The state parties have been careful not to do that. The national party hasn't, apparently, but the state parties haven't, because I think that really undermines our sense of justice, right? Voters don't like that. That might undermine a campaign. But it hasn't stopped hundreds of thousands of dollars from a national political party still coming into a state election. By the way, my understanding is news reports have suggested that the RSLC is continuing to look at a consultant who often works for them. I've seen reports is starting to dig around the state Supreme Court race this time too. So we may again see a national political party spending in a state nonpartisan campaign. This was just, it's a back in 2002, the beginning of these cases was this case that said that if you're going to have a campaign, you have to play by campaign rules. And that means that you can't limit who endorses who or who talks about what. In that case, you can't limit a judge from committing to particular positions as long as they're not commenting on particular cases. This final piece, so what's left after that? So it's possible by November we'll be living in a world without campaign contribution limits, where judges can be endorsed and accept endorsements from, right? This is, if the federal judges have their way under Citizens United, they're going to eliminate all of this. We're going to have partisan, unlimited contribution judicial elections this November. There are plaintiffs in federal court right now asking for judges to do that. What's left? Well, I think the response of the plaintiffs in these cases who are asking the federal courts to strike these long-standing state laws down. Montana's nonpartisan elections go back to 1937 or so. The contribution limits have been around since the 70s. What's left? Well, they say, well, you can disqualify the judges. If a judge is going to be impartial, you can always disqualify them. And the U.S. Supreme Court has said that actually you have a constitutional right to disqualify them in the Caperton case, where, ironically, in this case, independent expenditures from one of the parties before the court likely influenced the election of the deciding judge on a case that Massey Cole had. So Don Blankenship, who was just convicted of a crime with respect to one of his mines, a criminal disaster. Don Blankenship, whose company is Massey Cole, spent I think $1 million or more in independent expenditures to influence a race while his case was pending. His candidate won, his candidate voted in his favor. The Supreme Court overturned that because they said at that level, then you have a constitutional right. No matter what his First Amendment right is to speak, his opponent's due process right is for an impartial jury or judge, so that judge has to go. So that's what we're left with is disqualification. This is extraordinarily rare. I'm not sure we're aware of any other cases. There's one case that was up before the Supreme Court this term raising this question, but extremely rare to find cases that involve this. And the court was clear that this would be very rare. But there is that question of disqualification. In the Montana lower courts, thanks to the Copper Kings, we have what's called a Clancy rule, where any party can presumptively bounce a judge without any reason. But at the Supreme Court, there's no such rule, because you don't have substitute justices. So the Supreme Court, you have to ask the justice, him or herself, to recuse. You can try to file for a disqualification, but it usually doesn't work. The court does not like sitting on each justice's kind of ethics issues. Usually you have to rely on the justice themselves to recuse. That's, I think this is one of the final slides about how, in terms of this court and how we pick this court, those are some of the ways in which Citizens United has opened the door to unlimited, undisclosed money and partisan politics in judicial elections. And by the way, I wrote an article about it. You can find it at that link.
So I want to maybe start by going back and seeing if you could talk a little bit more about maybe the court's rationale and the movement away from attention to responsiveness or maybe responsibility to citizens to sort of the swing of the continuum and the swing of the pendulum all the way over to responsiveness to contributors, and what the sort of the logic and the rationale is to that movement.
Yeah, so I'm seeing, I may even have a slide that reflects that movement. The idea, and I think the court, I'm pretty sure the court's not being careless. They're smarter than that. So I think what's happening is a kind of long game of moving the court from, we'll talk about the court some members of it, who generally have a skeptical view towards campaign finance, have been playing this game of, I tell my students, it's like a game of telephone, except they know exactly what they're doing. They change the terminology bit by bit. So if you're going to find that corporations who can't vote have a right to speak in elections, and of course they do, they have a right to free speech, they do, period. So as long as there's no direct corruption threat, they have a right to speak. And what the court was saying in Citizens United was that it's not enough that if they exercise that right independently of the candidates, that may provide them access or influence later. But I think even in Citizens United, the court was speaking of that as a bug rather than a feature in the system. What changed was later cases where, particularly there's this McCutcheon case. McCutcheon involved a guy in Georgia, say, I can't remember exactly where he's from, who wanted to give money to everyone's congressperson or congressional race. So he wanted to spend money. He was in Georgia, and he wanted to spend his money in Montana, and you were capped in terms of how many other congressional races you do. And the court there, that's where it made the move to separate this and said, you know what? He has the right to do that, and the fact that he gets access to our congressman is not a problem with his campaign contributions. And that's where you start to see the disconnect. It's, well, actually, that doesn't seem quite right. And now they're starting to talk about it as actually part of their rights to influence other people's elected officials. So that has moved to a rather strong rule of permitting independent expenditures. Although there has been this case that was decided last year out of Florida, where they said, maybe we're not willing to go the full Citizens United with judicial elections. Chief Justice Robert was the one to defect from the Citizens United majority. We don't know how far that will go. For now, in the lower courts, as you've seen, the principle is free speech, partisan politics, and maybe unlimited contributions. And the lower courts have drawn no such distinctions between judicial and ordinary political elections.
So you just actually gave a nice segue to the next question that I wanted to follow up with. I know it's always a risky thing to try and guess where the court is likely to go, but have they given any clues? Have there been any hints to give us some sense of how they might distinguish judicial elections from other kinds? So, well, if you want to know where the court's going to go, tell me who's going to fill that seat there. Right? That's going to determine this. These are 5-4 decisions. But in this most recent Florida case, what the court said was Chief Justice Roberts said that an impartial judiciary. It was a case that said that Florida had said that judges who are running for election, or even candidates who are running for election, can't ask for money directly. They have to have their campaign ask for money because they didn't want that kind of to sully that relationship. And a candidate sued and said that violates, that's silly. I should just be able to ask people directly. And that's where the court said, no, impartial justice is actually a compelling state interest, one that's enough to trump the First Amendment interests on the other side. And in doing that, it was a little weird. It was kind of a reverse Citizens United, where the 5 justices spent a lot of time, and the Justice Ginsburg and others actually wrote separately, citing their own dissents in earlier cases that they'd lost, saying, yeah, that's exactly right. This is why judicial elections are different. We expect something different from judges. Of course, they said that before and they didn't have 5 votes, but now they're citing it again. Just like how in Citizens United, the majority spent a lot of time quoting from its prior dissents, saying, yeah, corporations have strong free speech rights and they should be able to spend. So those cases, by citing to the dissent, give us a hint of if, for example, the next justice is more in the mold of a Justice Breyer or even a Justice Ginsburg, we would see them, or even Chief Justice Roberts, we would see them show greater respect for judicial elections and maybe start drawing these distinctions. The problem is that these challenges come in and sweep away the whole laws. There aren't a lot of states that just have judicial election campaign finance regulations. And so the way the cases work their way up,
So in Montana, for example, we made a case that says our law is different because it applies to judges. The court didn't care. So they might think judicial elections are different. It's not clear that the current batch of campaign finance cases are going to give them an opportunity to distinguish between them.
Is there any indication that, and this is pushing far into politics perhaps, but any indication that state legislatures may recognize that difference and respond accordingly, that we may see a slew of new legislation that applies only to judicial elections in that case?
I think that's a possibility. I mean, the problem is that you have to go through politics to try to take politics out of it, and so it's not clear that the legislature that's foremost on their mind. They actually don't, they don't always like the courts. The courts are messing up their laws. They're striking them down. They're being independent and enforcing the Constitution. So that's a problem. Although I will say, segue to one of the fascinating things about Montana's constitutional debates. In 1972, the delegates proposing the Montana Constitution said they had a big debate over judicial elections or merit selection. And they decided after a big debate that we're going to stick with judicial elections for interesting reasons we can get into. But they also said, but if we're going to do that, we're going to have public financing. So the Montana Constitution, a draft of it, they put in public financing to take this tie with money out of the picture. Now, there could still be independent expenditures, but with public financing, the justices, the candidates wouldn't have to worry as much about it because they could still get their message out. It got in, they voted and took it out, they voted to put it back in, and then at the last minute, they voted and took it out. So it's not in our Constitution. But in terms of what might have been, there's real possibilities that maybe public financing could be a solution. And that might be a little easier when you're talking about judicial elections and other political offices.
Are there many states, you talked early on in your presentation about those states that use a merit system to select justices or to select judges. Are there many of those states that have no election whatsoever, that are merit only and there's no retention election subsequent to that appointment?
I can't remember the exact numbers, and the chart I have doesn't break them down. Most of those, they still have to sit for retention elections. I'm not sure which, if any of those states, they don't. And I'd be interested to know, so both Arizona and Maine, for example, are clean election states with public funding and elections. How that's played out in the judicial area. There's good political science that it doesn't always do what you think it'll do. It actually can increase polarization in some ways, but I'm not sure exactly how many of those states. Typically, the default model is that they run for retention. In New York, I'm not sure whether, for example, at the Supreme Court level, how often they run for election. But even in California, there's the famous case of people getting voted out. So.
Right. And part of the reason why I asked that question is to set some context for a follow-up question, which sort of gets into the rationale for why elect judges in the first place. Mm-hmm. There, in doing a little bit of research for today's conversation, was digging around to see if I could find information about the prevalence of corruption among judges in the United States. The obvious question being, well, so how does increased expenditures, increased contributions augment? Does it increase the amount of corruption that we find, or is there a relationship or not? And in the course of doing that research, I came across an op-ed by a former federal judge by the name of H. Lee Sorokin, who actually argues against the notion of judicial elections in the first place. And just to kind of quote for a moment here from his op-ed, he says, "I don't doubt that there are persons out there, even corporations now, who contribute to judicial campaigns for the purpose of electing or retaining judges who are fair, competent, and impartial, and who will carry out the applicable laws and enforce the state and federal constitutions. Then there are the other 99%, A little bit of hyperbole perhaps, hopefully, but the other 99% who wish to influence particular matters or judicial philosophy in general. And this is sort of the key point related to my question. Judges are not and were never intended to be elected representatives. I cringe at the constant contention that judges should be held accountable. They are accountable to the laws and to the Constitution. They should not be subject to the whim of those who find certain past rulings objectionable or seek to influence future ones by buying elections. And it sort of opens up this question of, first, are judges representatives? And I'm kind of looking to your scholarship in constitutional law here and familiarity with the Constitution to sort of explore that question, especially for me as a political scientist. And if that's the case, or really is it the case, right? So how might we think about judicial elections? How does that fit in our sense of American democracy and what the role of the judiciary is and so forth? I know that's a really big sort of combination of questions.
Well, I've said before that it took an elected state Supreme Court to recognize the problem Citizens United poses for judicial elections, and it took an unelected U.S. Supreme Court to completely show complete obliviousness to that. But I guess I'm not sure what the baseline is. I think the political science is very clear that the appointing president of a judge is a good predictor of decisions along all sides. So, are they representative? Are they corrupt? Are they paying back the president who selected them? I certainly neither of the latter. I don't think it means that they're representative. It does mean that while they are independent, the selection process can never be independent of politics. And look no farther than Senate Majority Leader McConnell and Chairman Grassley in terms of they actually are making a play to say that the U.S. Supreme Court should be representative of the results of the November election. I'd like to know how that works. Presumably they're expecting that it will be a Republican Senate and a Republican president. I don't know whether the filibuster goes away if it's a Democratic president, or does it take a Democratic president and a Democratic Senate? What happens if it's a Republican president? So I don't know exactly the proposition we're being asked to vote on there. But it's a federal judge can say that, and yet the political science says that federal judges also are, I don't think anyone says they're influenced, but from whether it's the moment of their appointment or the moment of their election, they are elected or appointed for a reason. And so that's pervasive no matter what the selection is, even at the federal level. In terms of corruption, it goes back to this question of what do we mean by corruption? I think in the days where they were trying to sort out some of these issues, why did they move from the federal model to partisan and nonpartisan elections? It's not, I think, because they thought that judges should be representative. They thought they should be independent. And understanding that they will always be accountable. Right? A justice on the Supreme Court, their accountability moment was when they were appointed, and they were appointed for a reason, with a certain set of views. Judges who are up in an election are accountable at their election. But they're also independent because they're not appointed by a politician, they're elected by the people. And that actually was the reason why in the history, it's fascinating, in Montana, judicial elections, we had very good reasons for judicial elections, because the alternative in territorial days was appointment by, in this case, Montana was a Democratic state, and an appointment by a Republican Congress. They, in 1884, in the newspaper editorial, when they were talking about the 1884 convention, statehood didn't take that time, but they were getting closer. The president has nominated another carpetbagger for the Associate Justice of the Supreme Court of Montana. 75,000 people in the territory to make laws for themselves, and a Hoosier sent out from Indiana to tell us what we have done. How long, O Lord, how long? In the actual document proposing the state constitution, this went to Congress. They said, we don't want appointed judges. Why don't we want them? The people have no voice in selecting the judges. They are sent to us from the far off east, probably in deference to the traditional idea it was from thence that all the wise men came. The character of our litigation is such that however learned in the law our eastern judge may be, he will find himself much embarrassed in his new field. Right? We had vigilante courts because we didn't trust the judges to have the quality of justice there. We had minors courts, customary courts. We didn't trust the judges, and not because we expected the judges to represent one party or another necessarily, but because we didn't expect them to know anything about what it means. I think we see repeats of that in the concern about outside money, out-of-state money coming in our elections. And I think that had some salience in the last election. When they talked about in 1972 whether to elect judges again, one of the leading proponents for judicial elections, he said, in Montana we have strong corporate influence, where if I can elect a governor and through that office nominate and appoint the district and Supreme Court judges, I can run this state. The actual Constitutional Convention, some of the preliminary committees were clearly dominated. They're all good appointees, independent, clearly dominated by these forces. And the only way to break that grip of corporate influence was to go to the people. He said, you cannot pick a committee in the state of Montana, a merit selection committee, for example, that is totally free of that kind of, in this case, kind of old-time Copper King corporate influence. I'm afraid of it, and if I have to choose between one or the other, I'm going to the electorate every time, because if I had it, this was a delegate who actually run for Supreme Court Justice. If I had a chance to be elected with another few bucks, I might have made it. But judicial elections don't come from an idea of representativeness or naivete about corruption. They come from a place of what does independence mean? And there's no way that we can have an independent judiciary unless we have a role in selecting them. Otherwise, we're just handing it to a politician who's as easily influenced by these special interests, or maybe more so than we are.
And it raises an interesting issue, and you started out your comments on this point about judicial elections historically being low information elections. Mm-hmm. We don't know much about them. And so whether party affiliation is an important cue, and one of my colleagues who studies electoral politics and studies Congress, makes a strong case that, or makes at least an empirical case, that there's reason to believe that partisanship and even negative campaign, stuff that we all hate, contributes and demonstrably contributes to the information that's available to voters. That voters in those kinds of races, even the really negative ones, are better able to distinguish the positions of candidates. My argument, sort of the counter argument, would be is that may be the case, but the quality of information is comparatively low. That if we want to have the sort of marketplace of ideas, having more robust, richer information, particularly policy and sort of platform information, is probably important. Nevertheless, we continue to have, I think, a circumstance with judicial elections where they tend to be lower information mm-hmm. than in other kinds of sort of comparable levels of elections. And the roundabout way to a sort of, I guess, a question here has to do with what appears to me to be a bit of a tension between the contribution of money into those campaigns and the possibility of having more information about positions, about the candidates themselves. But a big piece of that information, it seems to me, is about who's making the contributions, because that tells us something as well. And whether or not there's a bit of a disconnect between the transparency and the reporting requirements associated with where a lot of our campaign finance seems to be going, and the need for information and trying to enhance the quality of our understanding, our awareness, and our knowledge about potential candidates.
This is an area where campaign finance actually can do some good with disclosure. One of the arguments made in the '72 convention, but I mean, it's amazing to go back more than 40 years and find all of these themes coming up. But they'd said actually they talked about the importance of kind of the money primary for lawyers, and actually talked about it and that it was a good thing. If you have a system of capped contributions, you could have a system of public vouchers where everyone has the same amount. You actually have the opportunity for lawyers who, lawyers are going to know best just in terms of the quality of the judge, right? Whether they're qualified to the extent there's neutral criteria for that. And you see that, you're going to have that be a part of it. And so someone, even if they might fall on one or the other side of the ideological spectrum, you're not going to find a judge, you're not going to find a candidate who's going to be an awful judge, be able to raise money from anyone. And judges who have good reputations are going to be able to get a stake in terms of developing a campaign contributor base. So that actually might be a good way that we see lawyers making campaign contributions, because they help winnow out the pool early on, and they know best, as opposed to kind of outside groups that are relying on all sorts of other things. So, are there ways you could improve the information in judicial elections? Sure. New Mexico has a system of rating. It has a board that actually rates judges, and they put out a voter information pamphlet.
Unlike the ones we got from...
Right, yeah, that actually look to their positions and ask people in the state. So there are ways you can improve the information there. And actually the first time that Montana got rid of partisan elections in around 1910, the ballot fall off was huge. People just stopped voting. So they actually brought back partisan elections. But the second time they did it, not significant fall off. I think because Montana, and we elect a lot of people, our ballots are long, but because Montana's politics and because we still are of a size where we kind of know each other, we haven't seen that effect. And generally, the people have chosen pretty well in terms of picking justices. So there is a role there, and there's a role for the bar to provide some of that information. Maybe without being, and again, I don't want to sound as too much of a promoter of judicial elections, but in terms of the traditional defense of it, maybe better than the bar actually being a actual screening mechanism as they are in a merit selection plan. That's the concern, is that they actually are screening out people.
So let me ask maybe one final question,
Good, yeah.
kind of the grand summation, sort of look into the future here a little bit. So rather than asking you to sort of read the tea leaves and predict what you think is likely to happen, I want to ask a slightly different question, which is, if you had to, considering all of the current precedent cases, best case and worst case scenario, looking out, say, 5 or maybe 10 years into the future, what worries you, I guess, about the future of the judiciary in Montana, and what are you optimistic about or hopeful about in terms of the judiciary in Montana?
Well, the worst case scenario could come very quickly, depending on how these cases go, and that is a question of if the contribution limits go, it's going to get very bad just generally. Right, because there's nothing to back that up necessarily, even if higher contributions limits would be available. Those with judicial elections are particularly dangerous because they're going right to the candidate if they're unlimited. So that you don't even have the independence that Citizens United talks about. The partisan endorsement, if the candidates are able to accept endorsements, I think most of them will still be too smart to accept an endorsement. But we're going to see, I suspect we'll see more money from the national parties. Right now it's only been from one national party. I guess the worst case scenario will be that it's from both national parties. So that we might as well then send out a Sanford mailer and say that these people are backed by the National Republican Party and these people are backed by the National Democratic Party. Even if the state parties don't get involved. And so things could get bad very, very quickly there. And I guess the backstop to this, and this is the segue to the best case scenario, is the backstop to that is that voters in Montana actually care. Surprisingly, campaign finance, outside influence, these questions do seem to matter in elections. And so voters do get turned off by a concern that there's outside money in elections. So the backstop to that is that even if you have parties spending, both sides spending, even if there are unlimited contributions, we have a strong disclosure bill now, Campaign Finance Disclosure Act, the Disclose Act, enacted in 2015. Voters care about and follow the money. That can open up the path for a best case scenario where right now not only are the voters wary of outside money, but we could imagine with maybe some slight differences in the composition or the approach of the U.S. Supreme Court, that when these cases eventually make it up there, only one judicial elections case has come up, that the court step back and say, you know, judicial elections are different, create some space there, and allow Montanans and other states to continue to enjoy the principles of independence and accountability that judicial elections represent, but do it on their own terms and not on terms that have been dictated by the Citizens United era, where if you're going to have elections, they are wide open to as much money and as much partisan influence as you can bring to bear on it. If there's a change, it would only take a couple of cases to distinguish that. We'll be hopeful that it does, but in the meantime, I think the people of Montana, the people who enacted our '72 Constitution and even back to 1889, fortunately, I think the people of Montana so far have been too good to be to go down the road of finding this influence of partisan politics and money acceptable in judicial elections, and generally, so far, that's been shown at the polls.
Well, so as a political scientist, somebody that's interested in democratic practices, democratic processes, that's a pretty hopeful message to end on. It's good stuff. Well, thank you so much for coming out this afternoon. I really appreciate your time. This was really wonderful. For those of you who joined us, thank you very much. Thanks also to the Wheeler Center and the Political Science Department here at MSU for supporting this throughout the course of the year. Stay tuned for next year. We'll have another round of these.